Talking about warrantless searches here, and I told you I'd give you this PowerPoint presentation so that you could take the day off today. So let's go through these few slides on warrantless searches and talk about the most common type of searches that police officers typically do. You know, as we started out talking, we found out that the original Fourth Amendment of the Constitution required that all warrants by the government, and more specifically law enforcement, be done with a warrant. However, as we know, that would be really bogging down our system, and that most searches that police officers do today are done without a warrant. And so what's happened over time is the Supreme Court has made some exceptions to the Fourth Amendment search warrant requirement. And we want to go through those 10 exceptions here today. There's a couple of principles that need to be talked about when it comes to warrantless searches. Is that number one has to do with the scope of the search. Now, a police officer, when they're searching, especially without a warrant, are allowed to search for weapons, evidence, fruits of a crime, and contraband. Well, we kind of know what weapons are. We would kind of know what evidence are. If we arrest somebody for drunk driving, we'd be looking for alcohol, or if it was somebody that was involved in a fatal accident, we'd want to check the vehicle over to see if it was running properly and if there was any other signs of foul play and so forth. Fruits of a crime would be things that came from other crimes. And so while you're investigating a drunk driver, for instance, you come across a bank bag in the back that's all full of red dye, which would indicate that it was possibly taken in an armed robbery, a bank robbery. That's the fruits of another crime and is allowed under the rulings of the Supreme Court to be seized. And then contraband is that word that just means something that's illegal to have. Most of the time, it's drugs that come to mind when we talk about contraband, but it could be machine guns, it could be exotic birds. So anything that's illegal to possess in and of itself is contraband, and if a police officer uncovers it during a warrantless search, they're allowed to seize it and charge the person with a crime. The other concept that comes in when the court rules on whether a search was proper or not is they take the standard of reasonable expectation of privacy. And I'll kind of explain how that works in a couple of other things here, a couple of other examples as we go through here. But reasonable expectation of privacy is the standard. Police officers and law enforcement officers very often do searches, and when they're challenged in court, it usually has to do with the issue of expectation of privacy. Let's talk about these searches here, and let's just take the first and most common one here. Without this one, police officers wouldn't be able to function. See, under the old school, under the Fourth Amendment of the Constitution, in order for a police officer to search, they would make a traffic stop, find out there's a warrant for the person's arrest, take him out of the car, and have him stand there for about 2 hours while they went down to the courthouse and got themselves a search warrant, not an arrest warrant, a search warrant, and then come back and just say, okay, put your hands on the trunk of the vehicle. I'm going to search you for weapons, evidence, fruits of a crime, and contraband. Well, that's not very safe. That would take a number of officers to secure the person while you went down and obtained the search warrant. And so the Supreme Court at a certain point in time says, if a police officer is searching as a result of making a lawful arrest, the officer is allowed to lay hands on that person. The officer is allowed to search that person for that list that we talked about earlier. Also, the scope of the search goes a little bit beyond that, is that you can search the person and that person's, or those things that are in that person's immediate control. So if a police officer were to come into the room and arrest somebody in the classroom, they would be allowed to search that person. And if they had a book bag in front of them or next to them, they'd be allowed to search that also. Now, if there was another student sitting next to them and there was a book bag there, but it didn't belong to the person that was being arrested, at least under this pretense, they would not be allowed to search it because the student number 2 would have a reasonable expectation of privacy when it came to searching that bag. And so searching to a lawful arrest is the most common and the one that's used most often, and you begin to see how these exceptions came into being and how difficult it would be for a police officer to function out there if they didn't have some of these exceptions to the search warrant requirement. The next one we want to talk about is emergency. And all we're saying here is that a police officer is out there doing their job. They're driving down the road, 2 o'clock in the morning, they see smoke coming out of the top of a house. So they call for the fire department and they go running in the house, and as they're searching the house to see if there's any people in it, they realize that there's a whole box of stolen machine guns, or at least machine guns. We don't know if they're stolen, I suppose, there. Well, the officer gets out of the house and waits until the fire's over, and then goes back in and recovers the machine guns, and they end up charging somebody who's in the house or was in the house or owned the house for possession of stolen or illegal contraband weapons, machine guns. Well, one of the things that the person might do when they come to court saying, well, the officer wasn't allowed to see that. They weren't making an arrest or anything else. They shouldn't have even been in the house. And the court would say, well, you're right. Normally they would need a search warrant to come in the house. However, in this circumstance, the house was on fire. And because the house was on fire, the officer we expected our officers to go in there and do the public safety type routine. As a result of being in there, then the officer was allowed to deal with anything that the officer might encounter, which brings us to the next thing. If the officer is standing or is in a position that they're allowed to be legally, anything that they can see, they can seize also, which is the concept and exception called plain or open view. Now, I suspect there's some type of legal distinction between these two. However, I don't know what it is, and it's beyond the scope of this class here. But let's just say that anything that you can see with your eyes, you can get. So the officer going into the house on an emergency situation encounters machine guns on the floor, can say, well, I'm legally able to be here. I wasn't searching where I wasn't supposed to, where we wouldn't have found somebody who was burning up in the fire or have some type of problem there, that if I uncovered this in that spot, then I could say plain view, and the court would agree with that. The other distinction about plain and open view is the fact that the court does allow enhancements. And what do I mean by that? Enhancements actually means that the person walked, for instance, if you walked up next to your car after dark and looked inside, you probably wouldn't be able to see anything on the floorboard. But normally when a police officer stops someone and they walk up to the side of the car, they have this large flashlight. Well, with the flashlight, and they turn the flashlight on, they just might be able to see that the person down on the floorboard between the driver's feet has a open container of alcohol there, in which the officer would be able to seize the alcohol and possibly take action like open alcohol in a motor vehicle or minor possession. You can't argue in court that you had a reasonable expectation of privacy or that it wasn't in plain view simply because the officer couldn't have seen it with the naked eye. The court does allow and expect that an officer can use certain tools, such as a flashlight. The next one that we want to talk about is something called an administrative search. An administrative search, a couple of examples that I will use with that. One of them would involve a place that has a liquor license, a convenience store or a restaurant that has their own license. When you sign a license with the state of Michigan for these kinds of things, you basically give up your Fourth Amendment rights. And what that means is that occasionally, or virtually any time, but at least once a month, someone from a law enforcement agency or the Liquor Control Commission is going to come to your establishment and inspect it. And they're allowed to inspect anything, including things that might be locked up or behind locked doors. And the reason they do that stems from older times when there was a lot of bootlegging of alcohol around, and they wanted to make sure that you were paying the proper tax on all the things that you were receiving. But that still carries over today. And so giving up and waiving your Fourth Amendment rights would be, as part of getting a license, like a liquor license, would be an administrative search. The other one is something that's very common to most of you. When you go to board an airplane or other public transportation sometimes, or go into a public building like the 61st District Court. When you get there, you just don't get to walk in freely. You don't get to get on the airplane. You got to stop. You got to show them what's in your bags. You have to take your coat off. You have to take your shoes off and be subject to screening, security screening. Well, by our Constitution, that's a governmental action who is searching you. And under the Fourth Amendment of the Constitution, they should have to have a search warrant to do that for every person. But of course, the Fourth Amendment exempts them from having to do that. And if you don't believe me, next time you go through a security checkpoint at the airport, why don't you go ahead and ask them for a search warrant and see what happens? My bet you're probably not going to even get on the airplane. So another one that happens very similar to that is called a border search. You know, when we leave the United States, whether it be we fly out or take a ship out to go on a cruise or just cross over to Canada or Mexico, we know that we have to go through customs. Well, customs and the Border Patrol here are also law enforcement agents of the United States. And as a result, we assume that when we go back in, they're going to ask some questions and occasionally they're going to search. And again, under the Fourth Amendment, originally written, they needed to have a search warrant. And with a border search, they don't. They're part of the exceptions. So there's the first 5 exceptions to the search warrant requirement. So let's take a look at the last 5. The next one that comes up, and I've kind of just put this one on one slide here, it's called exigent circumstances. Exigent circumstances, and it's kind of an important one. It's also what I call the garbage can. It's when you're not sure what to use, sometimes you can get away with exigent circumstances. And actually what I've done is defined what exigent circumstances mean here. And here's what it is. Exigent circumstances is when the ability to search will be lost if the search is not immediate. The ability to search will be lost if the search is not immediate. And so what it's really saying is that the officer didn't really have an opportunity. They didn't have a chance to get a search warrant. They had to do it right now. One more point that it goes on and why it becomes somewhat of the garbage can is that exigent circumstances always exist with a motor vehicle. Exigent circumstances always exist in a motor vehicle. And what we're saying here is that because of the mobility of a vehicle, the court sees vehicles as qualifying for exigent circumstances. So, now, exigent circumstances don't always have to exist with a motor vehicle. Let's say you're a police officer and you're going to deliver a subpoena at a house, and you go and knock on the door. And when somebody yells from the other side of the door and you say, "It's the police, I need to talk to you," and all of a sudden you see a whole bunch of people running around, they're yelling, they're screaming, they're saying, get the stuff, throw it down the toilet, flush it down the toilet, get out of here, get rid of the drugs," and they're making all that noise. You mean you can't stand on the other side of the door and say, would everybody stop for just a minute, and I'm going to go get a search warrant, and I'm coming in there. Well, you know, by the time you get there, it's going to be flushed down the toilet and destroyed. So the opportunity to search will probably be lost if you don't do something immediately. And if the officer does go through the door and you do arrest someone and they challenge it, the officer would go in and say, "Well, the reason I searched, Your Honor, is because of exigent circumstances. I had to search right then. I didn't have the luxury of going to get a search warrant at that moment." So, but exigent circumstances sometimes just get a little out of hand, and so it's a very dynamic type of exception used by officers in a number of different ways, and that's why it's there. If you remember, towards the end of the class, or the beginning of the class, we took a pretest, and on that pretest, we talked about, or one of the questions of the pretest is that if you ask a police officer for consent, if they can search your car and you say no, they've probably or they will do it anyway. And I said we'd get back and answer all these questions in due time. Well, here's another answer to one of our pretest questions. Because the officer is being nice by asking your permission, but if you say no, if it's a motor vehicle, the officer would still be allowed to go search it under the concept of exigent circumstances. The next one that we want to talk about is inventory search. And again, another exception. You know, sometimes police officers come across vehicles. Sometimes they're abandoned. Sometimes they're a result of an accident. Sometimes the person gets arrested, like in the case of drunk driving. And now you have yourself a motor vehicle that you need to do something with. Well, in the old days, we just called the wrecker and had it hauled away, and we all felt everything was fine. Well, as different people would do, whether it was legitimate or not. Sometimes people, when they got their cars back, would say, "Hey, wait a minute! When you arrested me, or when you towed this car, I had a spare tire in the car. I had the leather coat in the back seat. I had a radio. I had $1,000 laying in the console." And so you really didn't know whether they were telling the truth or trying to scam you a little bit. And so what most police departments had to do is they had to implement something called an inventory search before they let the car go, because they had taken custody of the car also, as well as the person sometimes. They were required to go through a form and write down all these things and tell the condition of the car and what it looked like, and was there any damage to it, and was there a spare tire and a radio, and was there anything of value in the car. And they would give that inventory sheet to the record driver, and so we kind of tracked these things to avoid people coming in. Well, as a result of that, the entire car had to be searched, including those areas that someone under most circumstances would have a reasonable expectation of privacy, but not in this case. And occasionally you'd pop open a trunk and find something illegal, something contraband, or some evidence or fruits of another crime, like a whole pile of stolen radios or something. Well, what happened is that police officers started charging these people with crimes, and of course they came into court and said, reasonable expectation of privacy. You shouldn't have been in that trunk. You had no right to get there. You didn't have a warrant. Those kinds of things. And the court ruled that inventory is an exception as long as the police department does it for every single impound that they do. And so that's how they got the inventory as part of the exceptions, or one of the exceptions there too. Another one we think about is hot pursuit. There's still a lot of people out there that think that there's a free zone, is that if they get home, they get on their porch. It's like playing tag. It's ollie in free. When in fact, hot pursuit is hot pursuit. And if a police officer is pursuing someone, if they're chasing someone, and that person runs into a building, if that person runs into their house, that the officer has to stop short, that they have to stop at the front door. And that's not true. The officer can follow them in there. So if somebody runs into their own house, the officer chases them in there, and when they get in there, they end up arresting the person in a back bedroom, and while they're there, they come across a whole bunch of marijuana plants. Now those things are in plain view. And so they arrest the person for possession of marijuana too, and so they claim, well, yeah, they were chasing me, but they had no business to come into my house. Reasonable expectation of privacy. And so we want to suppress the search that got the marijuana. And you go, well, that's just not going to work. And so hot pursuit allows a police officer to chase someone even into areas that were in fact areas that the person would have privacy under the issue of hot pursuit. The next one that we talk about is consent. And consent is a really big one. It's one of those that's used in a number of different forms, but there's a couple of legal issues that come up with consent. The first one is the fact that consent always must be given freely and voluntarily. And it's really up to the police officer to show in court, if it gets challenged, that it was given freely and voluntarily. And sometimes that's a very difficult thing when you got someone who's a police officer and's got a gun and an authoritative voice and say, you don't mind if I search, do you? Well, that's not necessarily freely and voluntarily. Police officers are taught if they really want to make a consent search stick, they use one of the forms that they probably have with them that really spells out the fact that you're giving us permission to search and that you can refuse. Don't ever be afraid to refuse a consent search, no matter for what reason. And so it has to be given freely and voluntarily. The other important issue is that the person must have standing to give consent. And standing just means kind of like being in a position. If you were standing in the hallway in front of the door of my office, and I walked and I was still over in the classroom, what would come down? Oh, we gotta come on in, defense attorney here. So I'm talking to my class, Mr. Defense Attorney, and we're going through warrantless searches here. I'm recording this for them to listen to, and so you can object at any time in here. So, yes. So, anyways, I'm almost done with this. So, if you're here to sit down. But in order to have consent, the person must have standing to give consent. And a good example of that is that you're standing in front of my office door here, and you're waiting for me to come back from class, and the SWAT team comes running in, and they go, "Whose office is it?" And you said, "Mr. Ebel's." And they say, "Can we search that?" And you say, "Yeah, it's fine with me." And they kick the door in and start searching it. And I come in and say, "What are you doing?" And they go, "Well, we got consent from that person standing out in the hallway." Well, that person doesn't have. They're not in a position. They're not in standing to give consent. You can only get consent from me. And where that gets a little bizarre sometimes is whether or not a parent or a school official can give consent to something, and also some of you who live in apartments that have that you share space with. And so the rule of thumb, and let me give you a quick example of this that would work with a juvenile. Let's say it's a 16-year-old here, and I could get objected to here because I haven't run this past through my favorite defense attorney here yet. But he, let's say we have some stolen not VCRs, those are old school, DVD players at school, and as a result of that, I get three suspects. So I go down the street and I knock on the first suspect's door, and Mom comes to the door, and I said, "I'm looking for stolen DVD players." And they're very characteristic because when the school got them, they spray painted them orange just in case kids stole them so they could identify them. And Mom says, "Well, come on in. Now, can Mom give consent to search the entire house?" Well, most of you are going to say yes, but I'm just saying, well, based upon some of our principles, let's be careful and make sure we afford everybody their constitutional right. So the kitchen area, which is a common area, the living area, which is a common area, Mom's bedroom is a common area. But let's say when we get to the suspect's door, even if they're 16, one of the things the officer might want to ask is, "Mom, do you ever go into that bedroom, to your son's bedroom?" And she goes, "Yeah." And you go, "Well, when's the last time you went in there?" You go, "Well, this morning. I go in there every day because you know how those kids live, because they're nothing but a bunch of pigs. If I didn't go in there and fold up his underwear and put it in his drawers, make his bed and hang up his clothes, they would be." Now, under those circumstances, would there be a consideration of a reasonable expectation of privacy there? And the answer is no. And so you look around, you don't find your stolen DVD player. So you go to house number 2, knock on the door, and you do the same thing. You go to the kitchen. Dad, in this case, Dad's giving you permission. And now you get to a door that little 16-year-old Johnny here has not only closed, but they've padlocked it 5 times. They've put all of these signs on here says "Do not enter" and things like that. But you kind of know the answer, but you ask you ask Dad, going, "Well, you ever been in there? Do you ever go in there?" And Dad goes, "Oh no, scary things go on there. I wouldn't dare go in there." Well, I think it could be inferred that there's a reasonable expectation of privacy there. So now let's go to house number 3. We don't know if the stuff's in there, but let's go on to the third suspect. We do the same routine, go through the house, and now we get to the suspect number 3's door. And you ask Mom or Dad whether or not whether they go in there, and they said, "No, I respect my child's privacy, and they're responsible for their room, and so I just don't go in there." So, based upon that, but let's just say the door is open a couple of inches, and without touching the door or improving your spot in the hallway, you can see over on a table across the room what looks like a DVD player that's been sprayed orange. So what you have here is something, you got consent to be where you're at, but now what do you have? You have plain view, is what we talked about before. So as a result of that, you probably can go in there and seize that. So there's a kind of a rough application of consent, and it's important that you know that it must be given freely and voluntarily, and the person must have standing to give consent. The last one, and then I'll let you go here, is something called stop and frisk. And stop and frisk is a very unique one because it's not like the other ones. And the other ones, an officer, once they have permission to use one of these exceptions, can search for weapons, evidence, fruits of a crime, and contraband. But stop and frisk stems from a famous case called Terry versus Ohio. And what it amounted to is an undercover cop who was watching something else, saw somebody else casing a business across the street, walking back and forth, looking really suspicious. Something that we'd all recognize. And so finally the officer left their place, went over and identified themselves as a police officer, and even though the person didn't do anything wrong, they were on a public street, the officer, for his own protection, had the person put their hands up at the wall, and they patted down their outer clothing for weapons. And of course, as a result of it, the officer found a gun and charged him with a crime. Well, Mr. Terry challenged that, and it went all the way to the Supreme Court. And the officer in the case said, the only reason I did that is I don't like going home with extra holes in my body. I did it for my own personal protection here. I had a right to do that before I continued on talking to the person, and my hunch was right. In the Supreme Court, just like all of these other exceptions, they don't sit around every day and say, well, what do you want to talk about? Let's create an exception today. These are all cases that filter up there, and they have to make a ruling on it. And what they said is, based upon the circumstances of Terry versus Ohio, or the Terry case, the officer was reasonable in patting down the outer clothing for weapons. And remember that the parameter is narrowed from the other ones. They couldn't dive in their pocket if they thought they had drugs in it. They couldn't reach inside their coats. They patted down the outer clothing for weapons under the guise of officer safety. And there we ended up with our 10th exception to the search warrant requirements. One thing else about Terry versus Ohio, sometimes you may hear it referred to as a Terry stop or a Terry frisk. But Mr. Terry is the last name of the defendant in that case, too. So, anyways, I think that's the last one. Oops, yeah, pat down the other clothing for weapons, and that's the last slide. So anyways, there's a quick overview of the 10 exceptions, and you may see some of those on your next test. If you have any questions, make sure that you ask me about those next time.